Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for
I sing it every time. Cleavage / no cleavage. What do you call? I guess this would count as cleavage, William. I hope everybody is doing well today. We have had an interesting day. The colloquial we. You and I together, we've had an interesting day. I have my drink, my coffee. I just made it. It's not as hot as I want it to be. That's a lie. It's hot. It's good enough. It's just like drinkable, and I prefer it scalding. But, you know, drinkable is fine. I guess we'll just work from there and go on. So, just a little disclaimer. This is a live show. I am alive, and I will be talking. If you don't like that, that's okay. But please refrain from commenting about changing the format, because I'm not going to. Also, I would like to share with you guys today that I got a grammar Nazi in the chat, in a comment, which I just loved, getting mad at me because I forgot an apostrophe. And granted, I did. You know, I did forget an apostrophe, but they proceeded to explain to me what an apostrophe was, how to use an apostrophe, why it's important to use an apostrophe, and wished me luck using apostrophes going forward. I would, yeah, it was crazy. Jim, happy birthday. It's not my birthday, but thank you. So there was a slight misunderstanding earlier today over on Credence and Mikey. My birthday is March 25th. I'm an Aries, and we celebrated last month. The video that they showed today on Credence and Mikey happened on March 25th, my birthday. And because I am so annoying and mention my birthday so much, people knew that in the chat, even though I was not chatting at the moment. It was funny. So that I hope you meant that. Thank you. I know. So, okay, so maybe I overreacted, but my response to the apostrophe comment was slightly snarky. So I replied back and I said, thank you very much for your detailed explanation on what was a simple mistake. I will forever think of you every time I use an apostrophe going forward. Whoa, the shirtless dad, that's a big birthday. You'll have to come by. I can sing you happy birthday. It won't be good, but I can do it. Mikey said it was. No, Mikey knows when my birthday is too. It's Kay's fault / Pass's fault. Everybody's fault. And it's okay, but it is not my birthday. Listen, I just turned 36. I'm barely coming to terms with that. Okay? Me and my baby grand piano just sit there. I cry over it. Okay? But we can wish an early happy birthday to the shirtless dad. I think that would be a great idea. Miss Carrie, you know my birthday. That's right, girl. You know my birthday. Tomorrow is your cat's 14th birthday. Okay, if you do that, if you actually add that up into like a human years, long. That's old for a cat, right? I haven't seen that cat in a while. Ickadoodle, I'm sure she's fine. Oh gosh, I should have said that. That would have been so good, Lisa. I should save that for the next time somebody did that. Again, like I get why grammar is important. But hi Lucy. But it was just too much. Also, what really bothered me was that they had a misspelled word in their response, like intentionally misspelled. And I thought to myself, like, well, are we just cool with your flippant usage of the English language because you know the rules, you can do whatever you want, right? Miss Carrie, you thought you're turning 42 this year. Come to find out you're turning 41. Fucking fuck. That's pretty good. That's pretty good. Your mom sounds smart. You'll live until you die. Well, I will admit that I have had a 16-year-old daughter now for like 2 years. She's 15 turning 16. My brain just like brought her to 16 really fast. Oh god, Sashina, all I read on the side chat, it shows I'ma have a baby. And I didn't see goats. And I was like, oh my gosh. Sashina is pregnant. No, don't let me start rumors. Grim. Why don't you spell good? I didn't even blame my Canadianness. I could have, but I didn't. Anyways, so we have 4 videos along the bottom here that I've already. Hey, Mike, drive by. We were talking about you the other day. Good to see you and hear you. Oh no, I do have. I just saw these like frowny lines there. I gotta smile more. That's funny. Tell them the secret isn't dying. I like that. I like it a lot. Oh God, Bill, that's hilarious. Okay, so like I said, we have 4 videos to watch today. One of them, which is the title of this stream, is indeed about, it seems like a child support case where the guy is not the father, but the judge is not having it. Hello, hello, hello. Replay crew checking in. Also, thank you to all the lurkers and the replay crews. I always forget to say thank you to you, but I appreciate you. So thank you. Let's go. Oh, right. Yeah. So this first video, I filmed it in 2x speed, so I had to slow it down to half speed. But the judge deletes them, and I was a bit off my game this morning. So that if you're hearing a little bit of a tinny sound to it, that's why. Oh, Iowa's currently lurking, but will be on replay later. Awesome. Make sure you guys go check out Iowa's Backyard Critter Cam. A Backyard Critter Cam. You know what would be really funny? Iowa, is if for next April, you sent people out to do stuff during the day on the critter cam, but just like they're people, like dressed up like a squirrel, maybe. I think that would be hilarious. I think that would be really funny. But have everybody act totally normal about it. So just like put in the normal time, like 7 o'clock squirrel, like a large man dressed as an Easter bunny hops in. Exactly, like perfect. But no mention of it being humans. Just be like, there's a bunny. Oh, yep. Saw a dog, whatever. Like it would be hilarious. We won't tell if you want to write that down for next year. No. Okay, so like I said, 2x down to 0.5 up to 1. That's how we do the math. Let's get this going. Please like and subscribe.
You both can put your hands down. Now, sir, please state your first and last name.
Hagler, wait.
And ma'am, your first and last name.
Kendra Tidwell.
Counsel for the state.
Gabriel Artiaga with the Office of Attorney General.
Okay, counsel for the state, is this an agreement, a hearing? What do we have?
It's a hearing. Mr. Waits does not agree.
Okay, and how much time are you requesting?
5 minutes.
Okay, you may proceed.
Thank you, Your Honor. The state's going to call Ms. Tidwell first. Ma'am, do you have any objection to the state's request that the court grant our qualified domestic relations order?
Yes.
You do have objections, or can you please
Can you
clarify?
repeat
Do you agree to our request for qualified domestic relations orders so that basically Mr. Waits can help pay down his child support arrears?
Oh, no, I don't.
You're not in agreement with the state's request?
No.
And
So these two people think that I think they think they're going to play the system. I really don't understand it. But they came into this hearing thinking something else was going on. No, you have not missed almost anything at all. We just getting started, literally 1 minute in. 1 minute into our first court. Now, his money, if a qualified domestic relations order, is for his retirement benefits, right? Or his 401k. Like that is what lawyers often complain about being difficult to deal with when they're dealing with a pro se case, one side pro se, one side represented, because quadros are part of the judge's order allowing the transfer of those retirement benefits from one to another. So it sounds like he has a job and benefits, like, and retirement benefits. That's what I'm trying to figure out, you know? Yeah, we're still getting the batter to the plate. Welcome to Paisley Baseball. Takes fucking forever. But that's just like regular baseball. And you'll fucking like it.
why not?
Because how the case took place.
Okay, can you be more specific?
Basically, he was placed on child support for one of my kids that is not his.
Okay.
Mhm.
So who are the two children on this case?
Kamaria Wakes and Amaya. Her last name is Wakes. I just haven't switched it over.
Okay, and you're saying that one of those two children is not his, correct?
Correct.
Okay. And that's why you're objecting to our request?
Yes.
Okay. I'll pass the witness and call Mr. Waits. Sir, it's my understanding that you have the same objection, correct?
Yes, sir.
Now,
Basically, like I said, It's really been like real hard, and
You're about to hear how little the judge gives a fuck about how hard it's been for you, sir. Um, again, please keep in mind I watched this originally on 2X, and so it came fast and hard, but that's what she said. That's what she said.
I just
He's
want
gonna ask you questions. It's not a narrative.
I got you.
Okay.
Okay.
So let me summarize it real quick, Mr. Waits. You don't agree with the arrears that are already in place because one of those children is not yours. Is that correct? That's about what Ms. Tidwell said. Is that correct?
Correct.
Okay. I'll pass the witness and ask that the judge grant the quadro anyway. As the court knows, even if this gets modified in the future, and we confirm the child is not his, it doesn't retroactively modify the child support. So the arrears are what the arrears are. The state asks that the court go ahead and grant the quadro anyway.
The law is that he was found to be the father of the two children. If you wanted to challenge that underlying order, you should have challenged that, Mr. Waits. That is something you would have to file yourself or hire your own private attorney and file in district court. That's not something that I can hear. You can't just say, child's not mine, because the court order says the child is yours. It's not that simple just to say the child isn't mine. So there's a court order stating that you're the biological father of two female children subject to this case. And that order was entered December 16, 2010. So if you disagree,
14 years, sir. 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 Oh my God. Oh, that's never getting overturned. Not gonna happen. Is he nuts? Now, here's the thing. And this is what I've seen Judge Webster from Texas do in other cases. He says, listen, ma'am, you don't agree that that's your child and you don't want the child support from him, then you can give him the money back. You're allowed to give him the money back. You don't have to keep it, but I have to get it collected for you. So that sometimes dissuades the situation. They look too young to have a kid from 2010. Do I look old enough to have a kid from 2008? Yeah, Graham, right? I was going to object to it earlier, but I was busy. It might be it. I'm sure it's about Medicaid. I'm sure having the children on Medicaid is triggering this review. But still, what an odd situation, you know? I 14 years, 2010.
agreed for whatever reason, you might have disagreed to it. You should have legally challenged it. You can't just tell me that, okay? So I can't just
I get that,
undo
ma'am.
it because you said child isn't yours. So at
At that
this
time, Judge,
juncture, at any time, not in just 2010, at any time between 2010 and today, you had to legally file something to challenge that. I don't see that you legally filed anything, you nor the mother. Did you
Oh.
legally file any pleadings, Mr. Waits, to challenge that you were not the biological father of the child?
me and the mother have both have went up to the court before and tried to get this settled, and at
So
first
see,
they tried to tell us
trying means you did not legally file anything, did you?
we didn't know the steps. We just went and talked to what was that when
You
we
have
went
to
back
hire an attorney. When you don't know how to do something, you hire an attorney. You can't just go and talk to someone. Nothing will get done just talking. You have to file legal pleadings. So you didn't file any legal pleadings, correct?
Yeah, as of right now, no, I haven't.
Okay, so basically that's 14 years that you did not legally challenge it. That's what you say. It doesn't make it so. And Ms. Tidwell, you didn't file anything either legally, did you?
No, ma'am, I didn't.
Okay. All right. So with that, the state is asking that I honor the order under Texas law that states he is the biological father of the children and he owes that money. So by Texas law, that's what I'm going to do. Now, Mr. Waits and Ms. Tidwell, you disagree with my ruling? I assume you do. Appeal my decision. You would have to file something yourself or hire your own private attorney. You can't go talk to nobody at the courthouse to get anything straight. Hire an attorney. You would have to file it yourself or the
Mhm.
attorney in order to challenge it. I am going to sign the order for the quadro. You both are going to receive this copy via the email. And the Attorney General's office is not going to assist either one of you with an appeal or challenging that underlying order. You would have to do it yourself, or again, hire your own private attorney. You have 3 working days to appeal my decision. You will receive a copy of the order today via your emails. Okay?
Yes, ma'am.
All
I'm
right.
fine for sure. Thank you.
Okay. You
That's the end of that one. Hi, Crystal. Hope you're doing well, my friend. Always thinking of you, sending you good thoughts. That, like I said, the end of that video. Okay. Eeny, meeny, miny, mo. Catch a tiger by the toe. If he hollers, let him go. Eeny, meeny, miny, mo. My mother says to pick the very best one, and you are not it. All right. We're going with this one.
May it please the court, the state appears by Brenda Baskell, Assistant.
Whoa, Brenda. You're new here, Brenda. This is all new here. Give us a minute to get situated, please. My goodness. Look at Alex Herman, J. Alex Herman over here. Just absolutely brow heavy face. This was titled No Contact. I'm really hoping that it's a no contact order or a violation of one. But I don't know. We will find out together, like I said. But it looks like we're in Ellis County District Court. Ellis County District Court. I don't know which state. I don't know. I don't discriminate. I download and record court left, right, and center. Should I admit that? Can I deny it? As I sit here beside the court, showing it? No, probably not. I stand mute. Never.
Ellis County Attorney.
May it please the court, the defendant, Cody Armbruster, appears via televideo conference and with counsel Alex Herman, and McCoy.
Right, this before the court on the defendant's request to lift the no contact order regarding Kristen Baxter, who I believe joins us today. Correct, Kristen?
Yes, I'm here.
All right, Kristen, the motion of Mr. Armbruster indicates that you are also requesting the no contact order be lifted. Is that correct?
Yes. Mm-hmm.
Right.
That's correct.
it's possible it's in Texas MV today. Sorry. I was hold on. Shout out to the guys in the truck on overtime. Tell me about it. They're working double shifts today. Anyways, I saw a drunky judge. Remember that judge that we were fucking convinced was drunk? The redheaded one from some part of Texas. Anyways, I was on a tear looking for hers. And so I was in Texas. But this is Judge Braun in Texas. Possible. Totally possible. Oh, in Kansas. Totally possible. Like I said, I indiscriminately download. Hold on, I'll tell you what it's called though. Oh, it's called No Contact. But I believe it's Kansas. I mean, I downloaded a bunch of them from the channel today. Okay. Anyways, let's listen to them talk about removing this. And hi, Loud, by the way. Hope you're well.
Breath.
Ms. Baskell, position of the county attorney's office.
Your Honor, we are going to object, but if the court is inclined, we would just ask that it be modified to the electronic communication while he's in custody. And then if he is released at any point, then we revisit it at that point.
Good. Mr. Herman?
Your Honor, Mr. Armbruster has two different cases pending. One is for a domestic battery. The others has some felonies within it. Ms. Baxter isn't the complaining witness in the domestic battery. It's the other case. In addition, we started a hearing, if Your Honor will recall, to modify Mr. Armbruster's bond and continued it. Miss Baxter is really the only source of support Mr. Armbruster has. And based upon that, we would ask that the no contact order be lifted.
Well, he's got plenty of support. He's in jail, so he's got a roof and he's got food and
he's got plenty of support. He's in jail. Jesus Christ. It's not as if he's lonely. I'm not sure, Judge, but I also don't think it's a good position to take that is she the victim? Is she the victim in the domestic? Because if she's the victim in the domestic, she can't be his support. He needs to fucking deal with that on his own. Right? Oh, Amanda, you got a kid from 98? Girl, I remember 1998. Jail has canned goods. The jail has a place to sleep. The attorney does seem very, very allegedly a victim in one of the two cases. See, thank you for listening. Running the comments is actually hard.
Here's what we'll do. I read the affidavit. This, Mr. Armbruster, at least according to the sworn affidavit, exhibited some significant problems, to say the least. And I think he poses a risk not only to Ms. Baxter, but importantly to the community at large. So here's what we'll do. I think Ms. Baskell makes an excellent recommendation. Ms. Baxter and Mr. Armbruster can have telephone, electronic type communication while he resides in the Ellis County Sheriff's jail. If he is ever released out on some kind of bond, then we will revisit. There will be no personal contact between Ms. Baxter or Mr. Armbruster pending a further hearing.
Okay.
So, Ms. Baxter, you can call him or have video contact with him during visiting at the jail, but if he gets out of jail, I can't make any orders regarding you. You're not subject to the jurisdiction of the court. Mr. Armbruster is. Even if you invite him over, if
Now, this is a weird way to do this. I'm a little bit perplexed. I'll tell you this. I know in some counties, excuse me. I know in some counties, they listen to the jail calls. I don't know if they have an AI like algorithm that's running that catches criminal conduct, or if they actually listen on purpose, or if they just do it on a case-by-case basis. But we all heard of those cases in front of Judge Simpson where they say the jail called this and she was on the jail call doing that and they were on the jail call doing this. So we know it's possible for certain jails to be monitored. And they say that they'll be monitoring. So my question would be, is the judge issuing this because he has a comfort that it will catch any bad behavior, or is he just monitoring it because he thinks he can't do much harm from within the jail? And so he's like acquiescing, and then like I'm confused on why the order is being made. Partially, basically. Seems odd to me. But I don't know.
police find him in your presence, he gets arrested, not you, when he goes back
Sure.
to jail. Mr. Armbruster, do you understand that?
Yes, I do, Your Honor.
All right, so you can have telephone contact or electronic communication, but no in-person communication pending a subsequent hearing.
Thank you.
Anything?
Thank you, Your Honor.
Is that clear enough? Do you have any questions about that, Mr. Armbruster?
No, Your Honor. No, Your
Mr.
Honor.
Newman, anything further from defense?
No, Your Honor.
Very good. All right. That case is concluded. You're free to stay or go. This public hearing, we have one more to deal with, but it doesn't involve you, so you're welcome to stay or go as you see fit.
I'm gonna head out.
All right.
Okay.
And Your Honor, that's all I had, if I may be excused.
You may.
Alex, I need to speak to you if I could have you come up and visit.
We'll discuss that later, okay, Cody?
All right.
Okay, the next case is, I know, I'm not sure if I pronounced this correctly. Is it Chaslin or Chaslin?
Yes.
Which one? Chaslin?
Chaselin, yes.
Chaslin.
Chaselin. Sean, did you watch that on my channel that he started out at 92, but then he had $8,000 in payment, so it was actually $84,461. Why do I remember that number? I can't get it out of my head. I wanted to put $92,000. In fact, that's the title of the video, but not the title of the YouTube video. Like, it's the title of the file that I made. Anyways, I saw the same case. Oh, and 26 cents. I did not put that on there. Man, that people are talking about that case. Nobody's talking about the 26 cents though. You guys are so sweet. I love it. And honestly, I wouldn't be surprised if it was on another channel too. I just was like, wait, I remember that because I literally wrote it out and made $92,000, and then I was like, fuck, it's 84. You can't clickbait, Paisley. You got to put the proper one on the title. You know, they didn't mention how many kids he had, but I don't think it was as many as we think. Anyways, Miss Jody, we are thinking about you and love you, and are here for you if you need us. You let us know. He it was a crazy case. You watch it. It's a good case. Anyways, let's see. Apparently we got Chaselyn. Oh my God. Is she perhaps the chase goddess? What if she's the chase goddess? Not Tom. Is it a good place to find chicks? Down on their luck? Coming out without a buck? From the guy they used to fuck?
Okay, very good. Want to make sure I pronounce it correctly. Okay. This is State of Kansas versus Jesse Mackey, 24 CR 135 announce appearances.
May it please the court, the state appears by Brenda Baskell, Assistant Ellis County Attorney.
Record will reflect the defendant appears in person and pro se. This is a request to lift the no contact order involving Chaselyn Jimenez. I see that the defendant was charged with a level 5 aggravated battery. Is that correct, Ms. Baskell?
That is correct, Your Honor.
Level 5 aggravated battery. Which one of my lovely people is going to look that up and type it in the chat for me to read aloud in a moment? In Kansas, what a level 5 aggravated battery is. Doesn't sound good, buddy. Let me tell you. It doesn't even matter how many levels they are. If it's the top level, shitty. If it's not the top level, still 5 above the bottom, right? Now coming out to the main stage, ladies and gentlemen, put your hands together and your fingers in your wallets. It's Chaselyn.
Okay. And Ms. Jimenez, what is your position regarding the no contact order?
Just like how I feel about it.
Well, do you want it in place? Do you want it removed? Do you want it modified?
I'm willing for it to be dropped. I don't feel like, I'm at threat or, our son.
My self-esteem is definitely not improved enough to understand that I am worth so much more. So much more. I always wonder what happens. They have had a no contact order. If it's in place for any amount of time, why do they know that they still want this no contact order removed without being in contact? Chaselyn. Sorry, I shouldn't victim blame.
I want him to be involved with our kid. So, but yeah.
Okay, so how old is your son?
So he will turn 4 months on the 8th.
All
So
right.
he's pretty new.
Yes, he is.
That's such a dangerous time for a baby, a wee baby. You cannot have somebody who has a level 5 aggravated assault around a fucking 4-month-old baby girl. No. Sorry. No. I'm putting my fucking foot down. No. Please, judge. Please, judge. Please. Oh, please. I haven't watched this. I really hope that he doesn't do this. Judge, think about her. She is so vulnerable right now. She's young. She just had a baby. Oh, no. Now I'm all concerned. A 4-month-old wee babby. No. What if he cries all the time and Buddy gets pissed about it? He obviously hurt an adult. Exactly. That's a good point too. A 4-month-old won't remember if dad's away getting help.
All right. So what you're really interested in is Mr. Mackey having some kind of contact with his child.
Yes.
What about you?
Me as well. Yes.
We have a lot of options available regarding a no contact order. We can modify it to allow some type of contact, but just not unrestricted contact. So I want you to think about that. In other words, you just heard the earlier hearing, did you not?
A little bit, yes.
Okay. In that hearing, I'm going to allow the parties to communicate electronically, in other words, by phone, text message, video, that type of thing, but no in-person contact. When we have cases like this involving minor children, and the reason I'm bringing this up is we have an aggravated battery here. This is well, involved medical intervention. As I understand it, you had to get stitches. And so this is something that we have to look at much closer. It's not your usual domestic battery, which is a B misdemeanor. This is a level 5, which is a serious felony. So Ms. Baskell, the position of the county attorney's office.
Your Honor, we are going to object to it. Like you said, it's a very serious situation. There is a small child in this, a baby. And Mr. Rutherford indicated to me that he does have concerns because I don't believe he has spoken directly with the victim, but his assistant has. She is not wanting these charges, and Mr. Rutherford is fearful of Mr. Mackey. You know, if he doesn't have contact, then he can't influence her testimony at a future date of a preliminary hearing. And therefore, we would ask for no contact at this point.
So the state's concern is interference with a witness.
Correct, and also for her own safety, as obviously, if she's wanting it lifted, I don't know that she is getting the significance of the danger that he put her in. I do believe he's okay with maybe if you are inclined to, because of the child, Mr. Rutherford is saying maybe only to contact regarding the parent parties to exchange the child, or he is able to see the child.
Ms. Jimenez, prior to these events, back on the 13th of April, how often did Mr. Mackey visit with the child?
Before all this happened, I don't know when before this happened, like any of this and before the no contact, I mean, he was pretty involved. But ever since the no contact, he
No,
has
I understand he can have no contact. I'm saying prior to these events, prior to the order going in, you don't reside together with Mr. Mackey, correct?
no.
So how often did he visit the child?
He didn't.
He didn't.
Oh, girl, fuck. You need to run. Somebody needs to help this poor girl. I feel bad. This is terrible. Miss Jody Gardner, we love you, by the way. Don't forget that. Let's show Jody some love in the chat. This is he's gonna speak up here. Stupid. I'm glad the judge is handling this like this, but ay.
Live together, sir.
Well, it said, I thought here it indicated that you had separate residences.
Well, right now, while there's a no contact order, sir, but before all this, we lived together.
Because it said here, Mackey was located at his residence, 608 East 15th Street.
That's where
What?
so we both lived there.
Oh, okay, that was, you both lived together. All right.
Yeah.
Yes, sir.
So I mean, and he works from like 6:30 and gets off at 8. So he's always gone prior to no contact and stuff. So, but
What? What did she just say? He's gone prior to the no contact? What's going on here? Something's sus. Look at her. Why are they on this call together? Why doesn't she have a victim advocate? Why? I have so many fucking questions and problems with this. If this case isn't complete, this should be a no-brainer. Denied.
on prior to no contact and stuff. So, but yeah, no, we live together.
All right. When is looking here, Mr. Mackey he hasn't even had a first appearance yet, has he?
I don't believe so, Your Honor.
Mr. Mackey, when's your next court appearance?
May 21st,
Have
sir.
you retained an attorney?
I'm working on that today since I'm off work. I took off for this, so.
Okay. You're working on it. All right, here's what we'll
Yes,
do. I'm going to leave the no contact order in place. However, I will allow you to contact Ms. Jimenez solely for the purpose of visitation with the minor child. If you're going to visit, you will have to do that someplace besides the residence, and you'll need to make the exchange in a public place. In other words, Dillon's parking lot, Walmart parking lot. I don't want you exchanging in any private residence, things of that nature, if you want to visit with the child. It's cumbersome, but that's all I can do right now. Get a lawyer, have your lawyer file a motion. We can have a full hearing on it and make a determination from there. I also, Ms. Pascal, note that the cut Ms. Jimenez sustained from this incident allegedly was when Mr. Mackey pushed her or struck her and she fell, breaking a mirror and cutting her leg. So it wasn't that he inflicted directly the cut that resulted in the stitches. However, the rest of the affidavit does indicate that Mr. Mackey was, according to this, angry and didn't act appropriately even after she was injured. So, and I noted also, this is, and maybe the affidavit wasn't drafted correctly. It said Mackey admitted to drinking the night before. So the officer asked him to submit to a PBT and he blew a 116. So I'm not sure what time that occurred. That may be in the police reports because the incident occurred at 2:28 in the morning, it looks like. So I don't know when he still blew a 116. So that also raises some alarm bells. There's a lot of unknowns in this case. So Ms. Jimenez, I'm going to put in here that you and he can have telephone contact only for purposes solely of arranging parenting time for him to see his son. Mr. Mackey's going to get a lawyer. He better get a lawyer and get this case in the right posture. If he can't afford an attorney, he needs to request the court appoint one. He'll have to fill out an affidavit showing that he does not have the financial capability to hire a lawyer. We can get a lawyer involved, and that will provide an extra layer of protection, knowing he comes.
so we can.
You can call her to arrange to see your son only. You are not to discuss the case with her. Don't put her in jeopardy of potentially getting charged with an independent crime. if she now comes in and would testify, nothing happened, it was all my fault, she could be charged with interference with law enforcement, making a false police report. If she gets up and testifies under oath that way, she could potentially be charged with perjury. This is not something to be taken lightly. Understood for both of you?
Yes, sir. So if I get a lawyer involved, we can have another
You
hearing.
get a
or-
lawyer involved, and the lawyer will tell you what you need to do.
Okay.
Okay.
Yes, sir.
We can always revisit this issue at a later date, but right now, with all the unknowns, I'm going to allow you to contact Ms. Jimenez solely for the purpose of seeing your son. The only time you two can even be present at the same time is for the exchange. She would hand the son over to you, and then you would hand the son back at the end of the visitation. Understood?
Yes, sir.
Any questions?
No, sir.
Ms. Jimenez, any questions?
Not that I know of, no.
Okay. All right. I'll write that on the order. So if you want to see your son today, for instance, since you're off work, after you speak to your lawyer before, you can call her to say and make arrangements and the exchange in a public place, that type of thing. Understood?
Is it understood, MB? Thank you so much. You rock my world. We are just about to finish this clip, and then we have a few more. This is concerning to me, though. Worried here. Worried.
Yes, sir.
All right, Ms. Jimenez, good luck to you. With
Yeah.
that, we will be adjourned.
Oh, thank you. Appreciate that. Hold on. Thank you so much. Okay. Next, we have a new court. Again, I haven't watched the video, so I don't know what it is. So, yeah, but that judge is no bullshit. I have a few more of his cases that I haven't looked at as well, but I'm gonna now. I'm glad I already downloaded them. Aw, that's so sweet, Bill. Appreciate that. Here we go. Okay, so yeah, let's just do the new one. And we'll remove that one. And we can remove that one. And add that one to search.
Thanks.
Kevin Hirschler?
Morning, you can come forward, sir. How are you today?
Pretty good.
All right. So this is case number 2024 TR 12039. Could you state your name, please?
Kevin K. Hoshlow.
All right, sir. You're here on one criminal violation of driving on a suspended, revoked, or canceled driver's license, and then 3 civil traffic violations. One of them is count A is a stop sign violation. Count B is a no mandatory insurance, and count C is display plate suspended for financial responsibility. So let me talk about the criminal charge. You can plead guilty, not guilty, or no contest to that, as we discussed. On the civil violations, you can plead responsible or not responsible, and I can take some information in a moment. If you plead responsible, then we can handle the case.
I would like to know who's responsible for this fucking camera angle. Like, who set this up? Seriously, who did that? Fletcher boy, was it you? Thank you. Thank you so much. Loud, always making me laugh. You guys are always making me laugh. Please make sure that you've gone ahead and liked the video or disliked it, but preferably liked it. Really appreciate that. Super helpful. YouTube Daddy Fickle Master.
today regarding those civil traffic violations. If you plead not responsible, then we would schedule a traffic hearing where the police officer would be subpoenaed to come in. You would come in and have a presentation in court, civil traffic hearing, and then they make a ruling on that.
All right.
Understand that?
Yep.
So let's first start with the driving suspended, which is the criminal violation.
Not guilty on that one.
Plead not guilty?
Yes, because I did not knew that my license was suspended since the court dropped the keys.
Okay. So a couple of things there. I can't defend the case to you, but
I know.
So sometimes when a license is suspended, they'll send notices to the last record of address that the motor vehicle has. So you may have not received that notice.
Yeah,
So-
because I went to my cousin's address.
Okay,
Yes.
so, but you're required to update.
It went to my cousin's address. How the fuck would it have gotten to your cousin's address without you having put that down?
The address with motor vehicle. I don't want to prosecute the case or defend the case. I'm going to enter a not guilty plea. You can talk to the prosecutor on, hey, I didn't know, I didn't understand or whatever.
Yep. No, I'm good because I got my license back this Tuesday, so I did everything what they told me to do.
Okay. Since you're entering a not guilty plea, that's going to put you in front of the prosecutor on that pretrial conference I explained. So why don't we just enter not responsible and not guilty to all of it, because they might want to package that if you'll have some information.
Yep.
Do you have the registration and insurance now?
Yep.
So what I'll do is I'll take copies of this.
This was on standby. I forgot to take off standby, so that's what happened.
What do you mean it was on standby?
I had insurance on my Jeep, but I blew my engine, and I just got the engine
I see.
fixed.
I understand. Okay. So let me take so this date of violations on 4/13/24. This is 4/15/24. Is this one? What is this one?
It's the same.
Same?
Yeah,
Okay.
because I can't find my other insurance and
Okay.
stuff. So
But on the 13th, you had it on. You didn't have it insured. You had it on standby.
yes.
Okay. So let's get a copy of this, and what we're going to do is prepare the prosecutor for it. You've got registration now.
Yes.
There's
Yeah,
those two.
I didn't know about that. So
And then, do you plan on getting your driver's license also?
yes, right here.
Oh, so this is your driver's license?
I did all this because
Okay.
when the car pulled me over, I did not knew. So I went to the DV like he told me, and I did all these like they told
Do you have
me.
your driver's license?
Tuesday.
Oh, okay.
They told me Tuesday.
Okay, so here's what instead of this, here's what we on Tuesday, next Tuesday. All right, so when you get your driver's license, just come back here if you would like to. Should he give us a copy of his driver's license after he gets it Tuesday, or just bring it to the pre-trial?
I'll probably just bring it.
Okay, so just make sure you bring your driver's license
Yeah.
to that, and then that can be worked into a possible deal
Okay.
for that.
Yeah.
So.
From the address.
Sure. I'll give those back to you. And do you still reside on Pine Street?
I got a house on 607 South Oak Street, and but I talked to my cousin. My mailing address is at my cousin's address,
Okay.
but
My mailing address is at my cousin's where I didn't get it. Dude, that's not good. That didn't work last time. Can you have plausible deniability?
you can send it to my house, 607 South Pine Oak Street.
All right, so here's what I need you to do, sir, you're the defendant, so you're just gonna write in your, information here. This is where it's saying your old address, and then what your new address is. Please include an email and phone number.
Okay.
So your information here, your old address, your new address, and you're the defendant in the case. So here, this is case 2024 TR.
I'm actually happy the cop pulled me over because I did not know all of this. So
You don't hear that every day, I can tell you that for sure.
well, it's true.
Yeah, okay. So if you want, take this and go to that little counter right there, complete that, And then just turn that back into my,
Can I confirm his number and then I can at least give him a court date and close out of this?
yeah, which number? That is a class 3 misdemeanor charge. I have your attorney waiver form here. You wish not to have an attorney, correct?
Yes, sir.
And this is your signature?
It is.
Okay, I just wanted to make sure you weren't
Yeah,
just warming up the pins.
It's hard to read.
No, that's okay. I get a lot of flack here that people can't read my signature, and I'm saying, well, yeah, now I got a good one. All right, sir, so did you understand the group advisory that I discussed here?
I did.
Okay, you have any questions before you give a plea?
I do not.
Okay. How do you wish to plead?
Not guilty.
Okay. And then your address says on Houston Mesa Road is still good?
Yes, sir.
Don't give
And
the
then
addresses.
5918. Let's make that a little more distinct. And then do you have an email address by chance? Oh, we've already got it.
Bowling shirt's back, you guys.
Thank you. And then you have your attorney waiver form?
Yeah.
Okay. And do you wish to have an attorney or not have an attorney?
Not have an attorney.
Okay, so just check that top box right there.
Yeah, I'm just. Top one you said?
Correct. Yeah, you don't want an attorney, right?
Yeah, I mean, I don't want to take time and don't.
This has the vibe of going to the DMV, doesn't it? Looking through a tiny little sort of slot, unable to see who you want to talk to. Filling out seemingly endless and stupid paperwork. I'm getting DMV vibes. Big DMV vibes. Hi, Rebecca. Hope you're doing well. Like I said, I hadn't checked this out yet. We're going to scroll through, see if there's anything good. Let's see, what do we got? Oh my God. It looks like literally a waiting room, a hospital waiting room. Oh, okay. She's got a choker. We're going to watch Choker Girl, and I'm going to put on my choker. Solidarity for chokers. Like, that's the most important part. It is. Don't fool yourself, Paisley. It is. Okay, choker on. Let's go.
You have.
Oh.
It's a class 1 misdemeanor.
Let's get a little fit check here first. Also, here's the thing. What pen is she using? Take a look at this pen.
Ma'am, this is case 2024 TR 12038. Could you state your name, please?
Samantha Bywater.
Okay, Ms. Bywater, you're on an allegation of driving on a suspended, revoked, or canceled driver's license. It's a class 1 misdemeanor. You were here on the group advisory. You have any questions about that? Ready to give a plea? Okay, I'm ready to take it.
Not guilty.
Not guilty. You have your attorney waiver form by chance?
Yeah.
What fucking contraption of a pencil is this? I'm being serious. What is this? Is the top part horizontal erasers? I mean, here's the gavel, Kate. I was thinking, like, she's so much trendier than I am. And she's going to court. I know it's an anti-theft matter. I know that this is somebody's personal creation to prevent people from stealing their pens. But I want to know more.
If I refuse?
Yeah, you're wishing to not have an attorney, correct?
Oh, okay.
So do you want an attorney?
Yeah.
You do want an attorney?
Yeah.
Okay, so if you want an attorney, then this case doesn't qualify for one unless you have some cause.
Okay, then no, we're good.
Okay, so then you check probably the second box at the top, that
court
you
has
asked for
determined
one and the court
not
told me
entitled,
that's
okay.
not qualifying. Yeah. Some people just say, no, I don't want an attorney, so I ask about it, and then I'm like, okay, that second box is probably more appropriate. All right, is your address still good on codes?
No.
Okay.
And yeah. Yeah, that works too.
Please, if you wouldn't mind, let me add a little bit of information to it here. Case number 2021. All right, if you would, you're the defendant here, if you would put your information here, and then your old information here, and then your new information here, and include an email. And if you want to, you can do that at the counter, and then we'll have a coordinate for you when you're back in the account.
This is so weird.
No matter when she comes up.
Bit check though.
I'll address that other information when she comes up.
These sounds are so familiar to Martina.
It's an uphill battle.
Mhm.
It's an uphill battle I have to do every week. I just reminded him again. It's a long form, so I'm not sure.
Ladies and gentlemen, next to the stage, this guy with a lot of hair.
Okay. Hello there.
Hello.
All right, sir. This is case number 2024 CM33. Can you state your name?
Dorian Rackley.
All right, Mr. Rackley, you're here on three charges filed along the form. You were notified by this complaint form. All right. Count 1 is domestic violence, an assault charge, class 1 misdemeanor. Count 2 is disorderly conduct under domestic violence statute, and count 3 is domestic violence criminal damage violation. All of them are class 1 misdemeanors. Were you here for the group advisory?
Yes.
Okay, so I know there are a couple people walked in a little bit late. All right, so you understand that there's a mandatory minimum on this charge because of the domestic violence. Each count of the domestic violence charge has a $50 address confidentiality fund fee and a $50 domestic violence fund fee and mandatory domestic violence counseling. So that's the minimum.
Except they're making it into DMV style. They're like, okay, so for each of the hits, it's going to be $50. You're also going to need to take a class and do a half-ass test to prove what you know for a very short period of time afterwards. Sounds still very much like the DMV.
Since there's 3 counts of domestic violence, that'd be $300.
Okay.
$50 in each one of those in each count. And then you don't have to do the same counseling 3 times over. That's a good news. So that's the minimum, and then the maximum that I gave in the group advisory on the class 1 misdemeanor.
Right.
Do you have any questions before you provide a plea to the charge?
No.
Okay. Do you have any questions about the attorney waiver form?
Would I be able to get an attorney?
Okay.
With this case?
Court-appointed attorney?
Yeah.
All right, so as of now, I don't see anything in the file that's requesting jail time.
Okay.
So those maximums that I told you about, as of now, we can remove all the jail portion of that, okay? So that would mean that there's fines and counseling that's ordered.
Okay.
If there was jail time, that would qualify this case for a court-appointed attorney, and as of now, there's not one. If that changes, let's see, later down the road, the prosecutor finds out that you've got some other issues that they think.
Oh my God. And if there was not a better time to get an attorney, sir, if it's this good, imagine how good it could be with an attorney. They will get this off your record. You don't want to have 3 DV charges on your record. Are you crazy? Please go get a fucking attorney. Oh my God.
That needs to be harsher penalties. They'll notify the court. We'll notify you, hey, you now have jail time request by the prosecutor.
Gotcha.
And this case now is eligible for a court-appointed attorney.
Okay.
Other than that reason, is there any other reason why you would want a court-appointed attorney?
No.
Okay, so knowing that, does that help answer your question?
Yes.
Okay, so you either inquired about an attorney, so are you wishing to get your own attorney still? Because you still can.
No.
Okay, so then you check the second box, which says that the court, I asked for one, the court said I don't qualify for one. That's kind of what happened.
No. Like the second one?
Yeah.
Okay.
Yeah, where it says that I requested an attorney, but the court informed me I'm not eligible for one.
Okay. Gotcha.
Okay, and I'll take that.
Actually, I think I heard about it on Credence and Nike. In the chat.
Any other questions before you give your plea?
No, sir.
Okay, how do you wish to plea on the charges?
No contest.
Okay. So no contest means that you're not admitting or denying, but it's treated as a guilty plea and the sentence will be imposed.
Okay.
I have to have you come back because there's victims' rights notifications. Are you by chance the victim?
Yeah.
Okay. So the victim can be heard, so I'll hear from you in a moment, but we have to officially, by the court, send you information, the victim, of this next sentencing date, so they can have a say-so. What would you like to say to the court, or if anything?
I just didn't want any of this. I told the police multiple times, like, I didn't want to press charges.
Okay.
Oh, Jesus. This hits so wrong when he's standing beside her, side-eyeing her. This is terrible form. Oh my God. Why are these being handled like this? This is so weird to me. It is her. That's concerning. Oh, jeez.
So I'll explain that, and then I'm going to have you think about your plea here in a moment. So in the state of Arizona, the police, as they did, they went ahead and pursued the charges and forwarded the charges. The prosecutor can do the same thing, even though the victim does not want cooperation. And the reason for that is, I don't know anything about the details of your case, but let me give you a hypothetical. Man beats wife. Wife's afraid to say, I want him to go to jail. State of Arizona takes that burden, says, you don't have to say yes or no at all. Or if there is...
The state of Arizona, did he say? Did I fucking find Arizona court? Is that what he said? If I was expecting that, I wasn't.
Is an act of domestic violence, then we shall, not may, we shall, they must make an arrest. The prosecutor shall move forward with the case, but they take a victim's input. So, they can proceed on a pretrial conference. So if you pled not guilty at a pretrial conference, they still can take the case forward. They still can pursue the case on all the charges.
Gotcha.
Or they take information from you. If you tell them circumstance of what happened, they may take that into consideration and may change this a little bit. So, with a no contest plea, you don't get the opportunity to talk to the prosecutor. And I absolutely understand. I want this done. I want to get over as quick as I can. Right? But you have 3 charges. There may be some type of plea bargain. There might not be. I might, by me telling you this, it might not be you might just get the same result. But with is this your girlfriend or wife?
Yes, girlfriend.
Okay. Being the victim that she doesn't wish all this, she wants, you guys are still together, you're here together, you came together. I don't have really release conditions that prohibit that I know of.
I didn't get arrested.
Okay, yeah, so I don't have anything to propose that can't be. She's not here saying, I want them away from me, I'm going to jail. None of that's taking place. They might listen to that if you and her go together to present you a plea.
Okay.
So I don't want to talk you out of what you want to do, but I do want to let you know that that's a possibility.
Would you?
This is terrible. This is bad form. So weird how some courts handle things and some courts don't. I didn't even know I followed an Arizona court. Look at me. I originally had a plan to do every state, try and get at least a case from each state, but I need a bigger office where I can hang up a thing on the wall. Otherwise, I'm not motivated enough to keep working on it unless I see it. Yeah, Debbie Davis would not approve.
It requires you to come back again,
Yeah.
and you've got to speak with the prosecutor. They'll discuss what they have. They have the police report and all that stuff, and you can say, and then you'll have a chance to speak as a victim. You'll have a chance to speak. You know, I messed up, whatever you wanted to say, and then see if they offer you something.
Right, so not guilty then?
Okay, so that would take a not guilty plea?
Yes, sir.
Okay, so then we'll have to have you come back an extra day.
Okay.
Otherwise, it would just be coming back for sentencing.
Right.
So this adds another day to it, but changing your no contest plea to not guilty. And we'll schedule you for the pretrial conference. And I've got your attorney waiver form here, and I've got your new address in Pine.
Yes, sir.
Do you have any questions on any of that I just explained?
Oh no, but I do have questions. They wanted me to show you this.
Oh, yeah, that you got your fingerprints done?
Yes.
Okay, yep. And they also send us a copy of that also.
Gotcha.
But it's good that they tell you to bring it in case we don't get it and receive it by the time you're here. So we'll get you that next court date here in a moment, and then we'll send you out of that, so you'll come back right here, and you'll meet with the prosecutor. If you can come, that's probably be beneficial.
Okay.
Tell them how you feel about the situation and proceed forward. And then once that's done, if they don't offer you a deal, you can change your plea back to no contest, walk out from that meeting, come right back here, we're back to where you were, and then we can finish it.
Gotcha. Okay.
Or they'll offer you a plea, we'll go over that and do it that way.
Yes, sir.
Okay, you have a P.O. box?
Yes.
All right, that's enough of that. I don't know what to make of it. I'll have to think about it later. I want to end with Judge Middleton coming back from holiday, talking about coming back from holiday. I love it when he does his little surreptitious, I wouldn't call them surreptitious. I mean, they are in some way, like his little chats with the chat before the day starts. So let's watch that. He describes something that happened with the Supreme Court of Michigan, I believe. And yeah, let's see. And that'll round us out for tonight. It's what night is it? It's Wednesday. So we still have Thursday and Friday. All right, Judge, take it away.
Good afternoon. Today is Wednesday, the 24th of April. We're actually going to do a little bit of work this afternoon. As I mentioned yesterday, I went to Cass County for a special hearing of the Michigan Supreme Court. The people in Cass County and the Pokagon tribe of Potawatomi Indians did a wonderful job. Potawatomi tribe is quite active with the tribal court there. And I'm not sure exactly how they refer to that, but anyway, they were a big part of it, and it was very interesting. And all of our Supreme Court was there, and a case was actually argued before the court.
Oh my God, Judge. People are interested in watching cases? MB, you're the best. Thank you so much. Best court host in the chat in the universe. I will have to agree. Thank you so much. Seriously. Like I said, first of all, look how tanned the judge is. He's just come back from his vacation. He's telling us about this thing he went to yesterday. I don't know how good this is. This is a landlord tenant docket. I was just gonna watch the first couple minutes, but we'll see how we do. Maybe it's good. Meg makes an appearance.
So I've been on vacation, as you know. I had a busy day yesterday, and then we are gone most of the day today. And we have one of the parties. I set two landlord tenant matters, each of which looked like it had some thorny issues. These came up before I left for vacation, and I set them here for today. Rather than take up time on a landlord tenant day, and I decided not to pull my hair back. I wore a suit today because of the Supreme Court hearing. So we'll let this go. Keystone does no longer attend our matters. In fact, Keystone is not our housing advocate anymore. Another agency, Neighborhood Inc. is that entity. And it looks like people are here and ready to go. So let me go ahead and turn this off. I will be back in the morning with arraignments, and I'll let it run a little longer then. Anyway, thank you all for saying hello. It is good to be back from vacation. As I said, I have meaningful work to do that I enjoyed doing. And looks like everybody is here, nearly everybody. I also met today with the Supreme Court media advisor, John Nevin. He'd been quite helpful to me in the past.
I was literally about to turn it off, and he said that, and I said, did he just say he met with a media advisor? And then I was like, I'm gonna have to listen to this. I find that very interesting. Very interesting indeed. Ladies and gentlemen, Meg. Ladies and gentlemen, Meg. Ladies and gentlemen, Meg. At your service. Looking just as classic as ever.
Welcome back to Michigan.
Thank you. I've been back for a couple days, but we were gone this morning. There was a special session of the Supreme Court held in Cass County that Judge Pattison and I attended. It was a nice service ceremony, actually conducted an oral argument on a pending criminal case, very interesting facts. And then we came back. All right. Amelia Parker is here. Let me give her a proper name.
Such Zoom skills, Judge.
All right, we have everyone we need but plaintiff's counsel. Ms. Kalmbach is here from Riverside, and Nadledge Zaretz is here. Ms. Bauer has filed an appearance on her behalf, and Amelia Parker is here. These had some similar issues, so I set them for the same time. Ms. Zaretz, can you hear?
I have not been apprised, Courtney. As of yet, nobody, I don't know. We can use our investigative skills to deduce that he was out of the province, out of the state. It's funny how I default to saying that. Even though I was like, I knew Michigan and I know like it's a state, but my brain just automatically, I said the P, like I went province. I find that really weird.
Me?
Yes, I can, Your Honor.
Ms. Parker, can you hear me?
Yes, I can.
All right, thank you. It's 2:28. Nobody is late. A number of judges from other counties were at this thing this morning. I had a nice opportunity to talk to the Cass County District Judge about how her landlord tenant cases were going. I think a lot of us are involved in the same kinds of struggles.
I was hoping, I think you met our attorney, John Duffield, a couple of times. I was hoping he'd really take Cass County under his wing. He had a couple of good cases in front of Judge Renfro, but for better or worse, John has taken another position up in Allegan County with the prosecutor's office. So he actually had his last day with us last week. So,
well, there are a lot of prosecutor opportunities to be had. I'm glad you're still here.
Oh, is that a little slight? Was that a Debbie Davis dig? Was that a Debbie Davis dig? I'm pretty sure that was a Debbie Davis dig. Good night, Miss Vicky. Yeah, I'm pretty sure that was a triple D. That was a Debbie Davis dig.
So you can put up with my eccentricities. Here's Mr. Visconti. He wasn't here. I think it was Carrie Zanin who was here last time. And Mr. Visconti drew the short straw and had to come to St. Joe County today. Good afternoon, sir.
Good afternoon, Your Honor. Robert Visconti, P61756 for Riverside Townhouses.
All right, we have two cases. These are set kind of at an unusual time on a Wednesday afternoon, but I had a block of time available and I'd set these off the regular landlord tenant docket. Carrie Zanin was here last time and Meg Bauer was here, not with a formal appearance, but on the side observing what was going on. She has filed an appearance in the Nadledge Zaretz case, so we'll set that one aside. Lori Kalmbach, the manager at Riverside, is here with us also. Let's start with Amelia Parker's case. As I said, some of the issues in there were similar. we determined, or at least it was alleged, that the arrearage was $4,016.16 through April. The defendant represented that there had been a balance that's been carried over for quite some time. She's been on a plan.
It doesn't work well when I'm on the screen. What is going on with that? I gotta work through it, but it doesn't. She does look like she's gonna hurl on my head, to be honest with you. Also, what angle is this? I am just perplexed as to where her phone is, like below her tits, but looking up at her, I don't know. There's no vaping in court, and I need my glasses to read the paperwork. Okay, thanks for the reminder about my glasses. But I'll vape in court all I want. Also, seriously, it won't play proper while I'm here. Watch.
Where she's been overpaying $100 per month over the rent to try to get caught up on the balance. And there were also issues about how the rent was calculated. Mr. Visconti, what's your understanding here today?
So, Your Honor, I do apologize that Ms. Sandin could not make a return appearance. She sent an SOS a short time ago. She's waylaid and delayed in another court for an in-person hearing in Flint. My understanding is that the $4,016.16 is the correct amount of rent. We have not received information from our client's office indicating that a different amount or any adjustment would be due. I would certainly defer to my client as to whether or not there are any issues with that calculation, but our understanding is that is still the correct amount that's owed.
Well, I had an understanding, and Ms. Kalmbach, if you could unmute, and I know you inherited some of this and you came to this complex, Ms. Cousineau and others were here before you, that Ms. Parker was in a program to get caught up on the rent. And now the company is asking for the payment of this large arrearage. What can you tell us about that?
I didn't find anything in her file that said she was on a payment agreement.
There's just a $4,000 arrearage?
Yes, that is correct.
Do you have any idea why it took so long for them to bring this action? If this is a holdover from 2023?
Yeah, it's got to be something that they started before I was here. I was looking in the dockets and it looks like, I'm not sure even when they first sent this to the lawyer. I see it starting on the ledger in February. But as far as seeing in a file, I'm not sure why they took so long.
Ms. Parker, what's your position?
What do you mean by that, Your Honor?
Well, there's a large arrearage and it's going to be due within 10 days or you're going to be compelled to move. Have you sought any further emergency help?
I have contacted DHS. DHS keeps denying me, saying it's not a non-eviction, which I don't understand that when it's court papers from you.
Well, and we tell them, we tell you, you do not need a judgment to get assistance from DHS. And then DHS tells people, well, you need a judgment. They don't by law, but DHS has a different view of it. Well, you're about to get a judgment, which is going to say that you owe $4,016.16 through April. It's going to go up when May hits. $185 in cost. The total is $4,201.16. I want you to present this. Now, unfortunately, they didn't give me a judgment. So Mr. Visconti, you or somebody's gonna have to get me a judgment with those numbers in it. Let's repeat. 4,016.16. Oh, here is Elizabeth Ellison, I'm not sure. Through March, excuse me, through April.
Through April, Your Honor.
$185 in court costs for a total of 4,201.16. Today is April 24th. There's 30 days in April, which makes the due day May 4th. We don't usually do these on a Wednesday. May 4th is a Saturday. So the date is May 6th. Now, Ms. Parker, you need to pay this entire amount or you're subject to being evicted. A partial payment will not prevent the writ of eviction. So if DHS says we're going to give you $3,000, you still owe $1,200 plus you'll owe May's rent. Now, I want to tell you something else. They don't have to evict you on May 6th. They can also work with you for up to 56 days in an effort to get the rent paid, then another 56 before they serve it. But apparently this has been in the offing for some time. They sent it to council in February. Here we are in April, almost May. So you're going to get this order from me, which is called a judgment. And that's what DHS is looking for. I want you to share this with them. I want you also to go to Neighborhood Inc. and see if they have any assistance they could give you.
Where is
I
that
also
at,
want, it's here in Centerville. It's in the paperwork I sent you. It's got the number on it.
Okay.
All right. I also want you to stay in contact with your manager, Ms. Kalmbach, and let her know what you intend to do. Otherwise, if you can't pay it, you're gonna have to move on or after May 6th, or they can get a writ of eviction and put you out. If you do move, you need to turn in your keys and give your forwarding address within 4 days of your moving. So apparently they did some additional research. There were no other issues. That figure is correct. You told me you paid an additional 100 in March and 100 in April. But this is an arrearage that's been hanging on for some time. Your rent also is market rate now, or closer to it. It's $700 a month. So, Mr. Visconti, have you got our email information?
Your Honor, I actually did just email over a proposed judgment to the 3B civil.
All right, very good, thank you. And I realize you came in on very short notice. Now, someone else came in for a minute from Cox's office, and I let her in and then she disappeared. So maybe Carrie sent out 2 emergency requests for help, and she got here and realized you were already here.
When the bathtub goes up, we just log in, Your Honor. So
all right, well, as you know, we try to start on time here.
Understood.
And but I understand. Well, in fact, that's one of the things we were discussing is what Zoom has done to the civil practice, and what Zoom has done particularly to landlord tenant practice. So here we at least try to start on time. But once you're there, you can't always control how long your hearing is going to take. Ms. Parker, I'm going to send you that order out in today's mail. I want you to share with DHS. And if you want me to email it, you call the court and we'll email it to you and you'll have it immediately. Anyway, it's a lot of money, $4,201.16. And then on May 1st, another month's rent is due. So let me repeat, share with DHS, go also to Neighborhood Inc., stay in contact with your manager, Lori. If you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving.
Okay.
Do you have any questions for me?
No, I'm gonna probably go down to the office because I do need to talk to her.
All right, very good.
I'll be here till
All right,
5.
good luck.
Till when, baby?
I'll be here till 5 today and 9 to 5 tomorrow. Okay?
I'm gonna try to walk down there. It's kind of hard for me to breathe today.
Okay. Yep.
All
All
right.
right, baby.
All right, well, she has a twin sister, and sometimes I joke around with her about whether it's her or her twin sister, but I didn't think she was in much of a mood for joking around today, so we just stuck to business. All right, let's talk about our next case, which is Riverside Townhouses versus Natledge Zaretz. She is here. Meg Bauer from Western Michigan Legal Aid has filed an appearance on her behalf, and we have a representative from Aaron Cox's office, Mr. Robert Visconti. Now, this one, there were some issues here about how things were calculated, whether rent was.
You were talking about her earlier. She was talking to the judge about him being out of town and he's just back from vacation now. I thought you'd be relaxing, Mikey. You're working so hard this week all on your own, doing extra shows at night, showing up on Tech Troublemaker last night. If you guys didn't get to visit that yet, check that out. Yeah, she called the lady kicking her out baby. And Meg is there. Meg sounds more mature these days. I don't know if it's just age or life that's gotten to her. Oh, shit. Are you serious? Oh, that's funny. I'll have to do a good one for Tommy so that he puts me in one. Meg has come into her own. Yeah, actually, Mikey, good question. Fletcher Boy wants to know if you think that Meg is a beast in the sack. Looks can be deceiving.
I couldn't even tell. It was 288, and then it was 81, or I don't know. And this is another long holdover on the balance, and the balance was substantial, $4,226.45. So what I had hoped was that both parties would meet with Meg at Legal Aid and discuss it. Meg and Carrie would discuss it while I was sitting on Siesta Beach and have a resolution when I got.
Did he just tell us the beach? Did he just tell us? I think he just told us the vacation beach. Oh my God. Yeah. Can be.
Back, but we have some unresolved issues. So let's start with you, Mr. Visconti. What's the Riverside's position on this?
So, Your Honor, I can tell you that I am aware that Ms. Bauer and Ms. Annan have had some discussions on this, and I believe that the parties are actually in agreement to adjourn the matter to continue to try to work it out. I don't know. I don't know exactly, to be honest with you, what the arrearage is right now. I'm reviewing the exchanges via email between Ms. Bauer and Mrs. Annan, and it seems as if there is some progress being made. But I can't tell you for certain what the arrearage is right now, taking into account the discussion that has gone on between counsel today.
Ms. Bauer, what can you tell us?
I can tell you that Mr. Visconti's representation is accurate, that Ms. Zanin and I have exchanged on this case, and that ultimately we're both in agreement that we need to look through some more documents to reach resolution. But as far as I can tell, we've boiled the issues down to two primary points of contention. The first has to do with the current rental rate and when that rental rate took effect. And at this point, the plaintiff contends that the rental rate from December of 2023 forward is either $288 or $299. The defense's contention is that rental rate should be $81.
$299 for the fucking month? Is that a joke? Oh my God.
Based on the most recent recertification that Ms. Zaritz received in the notice, that would be the rent that she has the notice for. So perhaps Riverside was attempting to correct some numbers, but that as of October 25th, the most recent rental rate that Ms. Zaritz received was $81. And so our position is that is the rental rate she should be at.
$81? Oh. What on earth?
At least until that changes. The second point of contention in this case has to do with the rental rate from January of 2023 through August of 2023. And Riverside contends that Ms. Zaritz's rent is $599 a month for that period of time. And the defense's position is that her rental rate should be closer to $92 a month for that time. And the basis for the distinction there is a calculation of Ms. Zaritz's income, including about $20,000 that Ms. Zaritz does not have, never had, and that we believe there is not a sufficient record to support. Those two numbers have roughly to do with some alleged business income, about $8,000 in business income, and then what appears to be an roughly $11,000 mistake in calculating the child support. Essentially was calculated twice. So as Mr. Visconti represented, Ms. Zanin and I, Attorney Zanin and I, have agreed that there's a lot going on in this case, and that really to get to the right answer, we just need to keep digging a little bit. But ultimately, if you take the defense's position, the numbers of overassessment come down to a little over $4,000. But this isn't solid yet because we're still calculating.
Lori, do you have a current alleged arrearage on Riverside's position?
Let me pull up her ledger.
$3,753.45 through March. Would that be accurate?
It sounds right. I just want to make sure that I get the right amount here. I just have to grab her ledger.
I have that through April, Mr. Visconti, based on the ledger I'm looking at.
Yep, April would be $3,753.45.
All right. And how much is Riverside say the currently rent is, monthly rent?
$288.
$288. So
All of these numbers are cheap to me. I'm sorry, but these are all low. Her voice does hurt, right?
if we added May,
$4,041.45.
3753.45 plus 288, 404145.
That's correct. That's what I
And,
got.
And legal aid believes their calculation is about $4,000 off. So we have a fundamental problem. The plaintiff contends rent is $288. Defendant contends rent should be $81. I don't have an escrow order in place. Is Ms. Zaretz making any monthly payment?
The last payment I have record was February 1st for $81.
So she hasn't paid March or April.
I suspect, Judge, that she would be willing to do that. The representation she made to me was that she had been under the impression her rent was $81 until she was served with the court paperwork, at which point she was surprised to see $288 and wasn't sure what to do at that point. So I don't think she's opposed to paying her rent, or is not intentionally withholding rent or anything like that, and has the ability to pay. At least was anticipating $81 a month.
Well, she should pay at least 81. Right now, April's rent is past due and May's rent is about to be due. So we're going to look for a place to put this. And I'm a little jammed up because I've been gone. So let's see what we've got. We don't have any other holidays in May. The drug court conference is in the middle of the week, so I won't miss any landlord tenant dates.
Right? Fuck. Judge isn't going on holidays in May. That's not true for everybody. Some people are going on holidays in May. How can you miss $81? Right? I'd be rich if my rent was $81. Well, I wouldn't be rich, but I would be able to buy groceries like all that I wanted, maybe.
That's next week. So let's see what we have. May 6th. That may be a little soon. May 10th. How about May 10th at?
Our holiday in May is called Victoria Day. I live in a city called Victoria, but it is named after the Queen Victoria. That's our usual May holiday, I think.
$10:30. Does that work for each of you?
It works for our office, Your Honor.
I might actually prefer May 6th, Your Honor. I have a likely contentious trial in Kalamazoo on May 10th.
All right, May 6th at 2:30.
That's fine with me, sir.
And that will work for our office as well.
And if we need to continue again, defendant is to pay April and May's rent. At $81. I'm not making a finding that rent is $81, that it's no less than $81. And so I'd like to get that coming. This is another one where this arrearage has come from the past. And in fact, right now, Ms. Zaretz, I don't think could even go to Keystone, ask for assistance, because we can't even tell how much money she owes. If Ms. Bauer's calculation is right, she doesn't owe much of anything. So we're gonna have to get to where we need to.
I bet if we added up all the hourly rates on this call right now, it would cover her rent for a month. Maybe 2, maybe 3. Imagine that. Paula, you're in northern BC. I'm on Vancouver Island. Southernmost tip, humble brag.
Get to. But the party's been working on it, and Ms. Zaret's missed out on all of this fun. And maybe you guys can get a little closer to the finish line before February 6th. So I'm sure I'll put other cases. That case day's already sort of filled up, but I stuck this in there. I'll try to save a half an hour for it. I have a bunch of landlord tenant cases starting at 3. So, Mr. Visconti, thank you for coming in on short notice. And the rest of you will address this further on May 6th at 2:30. And I'll look for that order that you emailed and sign it for Ms. Parker. Anything further we need to put on the record here?
Judge, will your staff put together that escrow order?
Yes.
Okay.
Sweet, then they're done. And Fletcher boy, funny you should mention that. So I tell a story. This is the last story I'll tell, and then we're going to say goodnight. It's been almost 2 hours. By the time I'm finished talking, it'll have been 2 hours. But I have had many jobs. Many. And one of those jobs was working for AT&T Wireless, dealing with American customers, and we were working on let me get rid of these things because they fuck up everything. So in training, they were like, people are going to ask you where you live. You can't tell them where you live. And I just thought, well, that makes sense. You don't want to tell people where you live, you know? But they were like, no, specifically people are going to ask if you're Canadian, and you're not allowed to tell them that you're Canadian. But we don't want you to lie. So I was like, well, how do you propose getting around that? And they say, all you have to say is, oh, I'm just north of Seattle. And I was like, but that's Canada. And they're like, don't worry, it's perfect. And true enough, people did ask us quite a bit where we were. And we weren't allowed to say we're Canadian or in Canada. We would just, and people would be really, really perplexed by my accent. Because, you're on the phone for quite a while with somebody trying to fix their phone plan. Back in the day when phone plans used to get booked up and people would owe like thousands of dollars. Oh, terrible. But they knew people would ask. They'd be like, are you from Minnesota? And I'm like, no. Anyways, as a reminder, I hope you had a wonderful time tonight. I certainly did. It was a great time. I appreciate each and every one of you for all that you do. Do me a solid. Go watch the video that I put on my channel about a bird. I looked up that bird. That's the fucking right bird. Okay. Do me a solid. Do that. Okay. Reminder, I love you. I'm proud of you. And I will see you in the next video. Bye. Love you, Miss Jody. We'll talk to you tomorrow. You have a good night. Bye.